Fantastic. So what I want to do is, after those headline intros, I want us just to go around very quickly this particular panel to introduce ourselves, because what we want to do is speak to matters IP. And it's a big amorphous word, and some people think about it and they're like, okay, fine, it's something I should have. As a creative, I guess I should protect it. So we'll speak to this from where we're coming from and what you're bringing to this particular conversation as far as IP is concerned. I'll start from Paula and work my way down to Paul. I am not lost on that particular pun right there. We shall start on this side. Paula, a quick intro of yourself in this conversation.
Sure. I'm an entertainment and corporate lawyer from New York, also from LA, but I've been lucky enough to be a guest of your beautiful country, Kenya, for quite some time. When I was in LA, I worked for 2 studios, Columbia Pictures, and also Warner Brothers, and then I moved back to New York and worked for DC Comics. So, thanks.
Thank you so much. Liz?
Good afternoon, everyone. My name is Liz Lenjo. I am an advocate of the High Court of Kenya, and I am the current chairperson of the Copyright Tribunal, which is a specialized court that deals with disputes regarding copyright. We're talking about ownership. If you have an issue where you're disputing, do I own the film, or where does ownership start? Those are the disputes we listen to. If a registration has been done to your exclusion as a rights holder, that is something you can bring before the tribunal. And when your work has been used without your permission and you never got paid, you come to us and we ensure you get paid. So I'll be sharing some of the successful cases we've had at the tribunal as well, so that we ensure we are securing and protecting our assets in the film industry.
Thank you so much, Liz. And lastly, Mr. Paul.
Good afternoon, everyone. My name is Paul Kaindo. I'm currently the Acting Assistant Executive Director, Legal and Technical Services at the Kenya Copyright Board. I'm equally an advocate of the High Court of Kenya with approximately about 12 years in practice. I specialize in copyright and related rights, and I've done that for the last 10 years at the Kenya Copyright Board. And at the Kenya Copyright Board is a state corporation that is established to administer and enforce copyright and related rights. And I'm sure you have heard about some enforcement officers coming from Kekobo who actually assist in enforcing and ensuring that your copyright is protected. I'm also a court-annexed mediator. I do mediate in commercial disputes and specifically in intellectual property matters with the buyers in copyright disputes.
Okay, thank you so much. So just by looking at the panel, we're definitely in the right space if we're talking about IP. And I think that's where we need to start, because like we said, it's a term that's thrown around quite a bit in different spaces. It's also been referenced here as IP being the backbone of your content. This is really the spine of what you're putting together. So let's look at this backbone. What really is IP when we talk about intellectual property? Let's unpack that for somebody who has the idea, knows the story they want to tell, but they probably saw it somewhere. You need to take care of your IP. Liz, let's start with you. What really is intellectual property for a creative?
All right. And I know our time is limited, right? So I think I will start from this place where we always hear, you want to patent your idea. That's what we think, right? See, that's what we're usually saying whenever we have an idea. Yeah? So I think I start from there because we need to clarify. We don't patent ideas, we protect the expressions of these ideas. So intellectual property law is the body of law that helps you know which protection mechanism to use. So patenting is the highest form of protection. It means you are the first person in the world to have ever created that particular innovation. So when you've created, you ask yourself, am I the first one in the world? And why this is important for creatives, especially in the copyright sector, is once you know and understand this, you also find yourself the right lawyer. Because if the lawyer tells you we are going to patent your idea, then you know you're in the wrong hands. Yeah? So I think that's where it's important to start. So patents are mostly for scientific innovations. The threshold is really high, as I said, first in the world. So novelty and newness is the threshold. And then in Kenya, we look at industrial applicability. Is film industrial applicable? It's not it's not mechanical, right? So that's the thing. Then now we have trademarks. We're talking about the protection of brands. What do you call your production house? Are you in animation? You created a fabulous character. You can protect it. Look at Mickey Mouse. It's a trademark. That's why it's been there forever. And then we have industrial designs, if we're talking about the beauty of things that you've created. So for example, the first time a chair was created, it was the beauty. Industrial designs looks at the beauty and not the functionality. So it's a combination of lines and shapes. How does it look? Like the Chiviari chair, for example. It's cute. It was an industrial design. I think by now, it's now become a common chair because rights also expire. And then we have copyright. So copyright is the mother of film in terms of protection. And copyright is very fluid and flexible because we look at the expression of now these ideas. We're looking at originality. Your originality and mine or our creativity will be different. We would all here draw a giraffe. All our drawings will be entitled to protection. The greatest misconception we have about copyright is that it protects ideas. No, we had the idea of drawing a giraffe, right? No one can take that. It's raw, right? But it's how you, Jeff, you will draw that giraffe, how Paula will draw the giraffe, how Paul will draw the giraffe, and how I will draw the giraffe. All of them are expressed differently. We will get copyright to it. And that's why even in the film sector, you will find that you cannot claim to have originality of a storyline of romance, for example. It's how you will express it. How will you do your soap opera will be different from how Paula will do her soap opera. So that is the essence of copyright. It's about the fluidity and then now interrogating what infringement now looks like so that then now you assess that. Just to go back now in terms of these rights, remember I said they expire, right? So for patents, after the 20th year, it goes into the public domain. Anyone can use it. For trademarks, they're renewed in Kenya every 10 years. In some countries, it may vary between 6, 7 years, up to 10 years. So you have to renew that. So you can use it for as long as you are interested in using it. And again, the day you fail to renew it, it will become fair game. Yeah. So don't wait until the 10th year on month 9 to start renewing your application. We know how government offices work. So you have to be very vigilant with your renewal process. Because remember also your competitors are keeping an eye out. And they'll be very quick to say, oh, Liz didn't. I'm on it quickly. And they snatch it from you. It's a property. Industrial designs, you get protection up to 15 years. And you'll find that industrial designs and trademarks can go hand in hand because we also have a provision to protect 3D trademarks. So if this is your creativity, then it's something an IP lawyer can help you identify an IP strategy so that then it doesn't fall into the public domain and it's still lucrative. And then now with copyright, copyright protects film. For a film, what are we talking about? We're talking about the script, the literary works. We're talking about the audiovisual, like now this recording once it's done, that is protected by copyright. We're talking about the sound recording, so if just the sound was used without our visuals, it's protected by copyright. And then of course now there's music, there's broadcast, there's architectural works, there's sculptures, artistic works, and software. Those are all protected under copyright. And now with copyright, with literary works, artistic works, musical works, those last for the lifetime of the author plus 50 years after death. So for those of us who are in film, and I know later we'll talk about it, it's really important that you understand that so that when you're in business and you're putting this as an asset, you're able to leave something behind that your people will inherit. Your people will gainfully enjoy the fruits of your labor while you are alive. And then with photography, which I forgot to mention, photography, broadcast, sound recordings, and audiovisual works, it's for 50 years from the date in which, or the year they were made. So those ones last for 50 years. Then the others are pegged on the lifetime of the author. Yeah.
Okay. Thank you so much for really unpacking what IP is. And I mean, some of the red flags that you see right there. If you're getting some assistance, you go to your lawyer, it's a film idea and you're being told about a patent, big red flag. You need to understand what you're doing and how you're protecting that particular idea that you're taking. And it's not the idea, it's the expression of the idea. Thank you so much for that. I'm also taking notes on this. I want to come to you, Paula, because now we have the categories and we know what IP really consists of. What is it meant to do? Because you're probably seated there, I'm like, okay, fine, it's not a patent, it's not a trademark, it's a copyright. Now I know. but what really is it supposed to do for me as a storyteller?
Copyright law, at least in the US, was developed for you, basically, the creator. It was developed to protect the creator and the control of the work that they have created. For instance, for the ability to license it, right? Or replicate it. Why? Because if we don't protect the artist, there's no motivation other than only passion. Most people can think about passion, that's great, but what about, food on the table? So the ability to gain commercially from your work is being protected as an encouragement to the creative community to express new things in new innovative ways. So there's actually a law out there, a couple of laws, that are made for you. And so I always get sad when I hear these, terrible stories about people losing their rights or didn't even know they didn't even know they sold them, because the law is just sitting there waiting for you and saying, please create, do, and if you do, I will protect you. So, and when does copyright vest? Anybody? Like, when is your work copyrightable? When do you think? Based on what Liz gorgeously just expressed. Anybody? Come on, give me a hand. I mean, this has got to be the sexiest panel you've gone to. Intellectual property law for film. Anybody? Okay. Yeah, go ahead, please.
He says when it's an original expression of an idea that only you have, that's when it's copyrightable. That's what he says.
Right, so I think that, Liz covered it has to be original, it has to be fixed, meaning, recorded audio, an audio recording or audio visually like this, or pen to paper, or paintbrush to canvas, or hands to clay.
Paula, I'd ask you to just hold the microphone a bit closer.
Oh, sorry.
Yeah.
I'm saying that it has to be fixed. The thing that you're trying to protect has to be. It can't be if you've memorized your script in your head, like all 100 pages. That's not copyrightable because it's a thought. It hasn't been fixed yet on paper. Okay. But the copyright protection afforded to you, we're going to talk about how to do it formally, but the copyright protection afforded to you vests as soon as you create this thing in a way that meets the requirements to be copyrightable. Originality, fixed, and expressive and creative, right? Something new and something innovative. So you don't know it now, but you are protected. All of your work is protected. We're going to talk about later the formalities for it. The formalities do come with advantages, big advantages, and Paul and Liz can talk about that. But just know you have this thing of value that is protected by the law once you create it.
Okay, thank you so much. And I just want us to move quickly, even as we give answers, just because of time. Not a problem. Paul, I want to come to you because we've understood the categories, we've understood why they were made and what needs to be done. But I want to take it from what you spoke about being the enforcer in the room, So I did my diligence. I actually put it together. I've put my copyright in place. But I've worked in a certain area and saw it being played or being watched or being heard. What should I do as a creative at that particular point? Because clearly, if they haven't paid me, it has been infringed. How is it enforced so that they don't get away with that?
Thank you. I'll begin by what has already been said and has been explained about copyright. Copyright, like you have saying, is a bundle of rights. So you, as a creator of this copyright, has specific exclusive rights, meaning it is only you who can exercise those rights that you have been granted in that work. And in terms of film in itself is not a copyright work You can't just film and you say this is a copyright work. Film is a combination of copyright. And there could be a lot of people who are involved. What the producer does is to bring together all those people and clear those rights. But there are a lot of rights that are within a film. So you'll have the right of the rights of the person who wrote the script. You have the rights of the performer. If there is music, there is the right of the composer. So there are a lot of rights that could be included in that. If there are photos that are in the film, those are copyright works. You have the exclusive right to reproduce those works. The copyright classifies rights into two broad categories. We have economic rights, and then we have moral rights. Those are exclusive rights only you can authorize another person to exercise. So if, for example, you have that film, it is only you who has the right to copy or reproduce. But you can, of course, grant that right to somebody through a license or an assignment. It is only you who has the right to publicly perform that right. It is only you who has the right to distribute. So all those rights are exclusively yours. So how does infringement happen? Infringement happens when somebody else exercises all those rights without your authorization. So when you move along the street or probably on the social media or on a broadcast, you see your work which you have not authorized to be broadcast or to be publicly performed, what you do is that you need now to take action. You don't wait for, like we said, Kekobo is a regulator. Kenya Copyright Board is a regulator. We have enforcement department who are copyright inspectors. These copyright inspectors, particularly at this age of digital age, you don't expect them to be on the ground and listening. Who is infringing, who is infringing? There has to be a complaint. So if you note that your work has been infringed, all you need to do is to take action. By taking action, either complain to the relevant authority, which is now the Kenya Copyright Board, or you can choose to go to court and seek appropriate remedies, whether to the tribunal or to the court that has jurisdiction to deal with those matters. So to respond to your question is that once those rights we have enumerated that you have been infringed, it is up to you, upon you, the person whose work has been infringed, to take action. So you don't expect the police to take action for you. You have to complain, and once you complain, the process is usually rigorous at the Kenya Copyright Board. Our copyright inspectors will do investigations, and we have handled a lot of complaints, and we find some of them will end up in court as criminal infringements, where a person will be prosecuted and fined or jailed. Or if you want to seek civil remedies, then you can file a civil suit. But before you file a civil suit, we do encourage right holders, because litigation can be very expensive. It can take a long time. You need to explore alternative dispute resolution. And at the Kenya Copyright Board, we do offer mediation service. Currently, it is free because we are testing stage, and we have handled a lot of disputes, and we are being assisted by the World Intellectual Property Organization, who have offered their platform for purposes of mediating copyright disputes.
Okay, thank you so much for that. At least we know if it is indeed infringed, what you need to do and how you get resolution for that. And if it's being mediated, they're offering free services for that as well. So please have that in the back of your mind as you look at the IP that you own. Please, very quickly, very quickly.
Paul, when you were saying, you filmed this thing, it's not copyrightable. Under Kenyan law, is it not the same thing, Liz, that where your rights actually vest as this thing is created?
Say that again, sorry. Say that again.
Could you ask the question again?
Oh, sorry. You were talking about how when you're filming something, your copyright your copyright hasn't vested yet. Like what you have filmed is not copyrightable. Did I hear that wrong?
Sorry. What I meant is that there are I hope I'm getting you the question clearly. There are rights that you have as a copyright owner. So what you do is you submit a complaint that would be in the form of either, you can send an email, you can also pop into the copyright offices and make a complaint as well. But and I forgot to mention that you can actually forward a copyright infringement complaint through eCitizen. Our services are on eCitizen, where you can forward your complaint and the Kenya Copyright Board will pick it up from there.
Okay, thank you so much for that. I want to just move it forward for those in the room as well, because I really said at the onset, we want to make this as practical as possible. So I'm here, you have told me it's not the idea, it is the expression of the idea. Hold on, is it in relevance to that, what has just been raised? Just hold on, we'll come very quickly to our Q&A, just because of time. We'll move it along. We can see the questions, the gentleman at the back, and right here at the front. We'll be noting those as we come to the audience in just a bit. But I want us to think about it from the lens of, fine, I have been told it's the expression of the idea. I've been told I have to put it down on paper. So I've sat down, I've written my script. How do I protect? Do I just take that and get it protected, Liz? How do I make that practical now that I know what I know?
All right. And that's a very good and important question, because as Kenyans, we always think shamba is the only asset we can have. Like, even our folks, especially us millennials, we were always told, if you're in the creative sector, you have nothing. Buy a shamba kind of thing. But your intellectual property is your shamba. In the film space, once you've created it, as much as copyright, you remember when I did the primer about IP patents, trademarks, all those ones, you require registration, except for copyright. For copyright, as long as you fixed it, you don't need registration. However, we have what is called the voluntary system, which Kekobo is in charge of. It's called NRR, nrr.copyright.go.ke. That's the URL, right? So when you create your work, if it's a script, that's a literary works, right? Because it's literature. You will put it together, go on NRR, and you'll register it, Liz Lenjo, ID number, select category of works, literary works, script, upload it as a PDF, and then Kekobo will do their thing, you'll get a certificate. Because that shows your proactivity in terms of asserting your intellectual property, it becomes your title. And it will be so much easier even when you have a dispute. The tribunal is also operating from a point of, okay, you registered, so you just have, already you'll even have the proof, whatever you submitted on NRR, that's where you really need to start. So whenever you're creating your work, you need to understand what am I creating and how am I protecting it. So if it's a audiovisual work, that means you would have already recorded it, then that's what you will upload on NRR. If it's a sound recording, maybe you are a podcaster, then you upload it on NRR. But also there are other ways also to do it, because sometimes the system may have an issue, because our files are very heavy. So even when you upload your content online, you have the date of production, and you give all these details, which, who are you, like basically give your work an identity. Those are called technological protection measures, or digital rights management in terms of all the information, so that people know this is Jeff's work, this is Liz's work, and everything. So that's where you start. And then aside from that, you see, the registration is not the start and the end, right? Copyright relies heavily a lot on contracts, because this is an ecosystem. We're working together, right? You're strong in copyright, in script writing. This one is strong in being a director or a producer. So-and-so is strong in lighting. And, there are all these experts and professionals that are in the system. So how do you secure your copyright or your rights? Is through contracts, so that you know who owns the IP and who is a work for hire, who is commissioned to just come, do a recording and go. And then sometimes that can change if you're working with a superstar, right? So if I had like Amina Abdi on my production, Amina is a superstar. So Amina, in Kenyan standards, because she's like one of our big stars, she can say, I want to share in the IP, because her performance in terms of how she'll bring life to the script and whatnot may vary. That's why maybe I picked her kind of thing. So then in that regard, then you understand that at a contract level, there's a negotiation that has to happen, and these contracts have to be very clear in terms of copyright ownership. We're seeing a lot of contracts that are omitting that. I don't know if it's an error in terms of maybe poor legal advice or self-lawyering, but a good contract will address who owns what, right? So that then now you're able to also, if there's a dispute, you have a contract before the tribunal and say, hey, this is my work. I want to give a very good example, a recent case that we determined. In film, we had Kada Media, and I think Diana Mbogo was the scriptwriter versus Wananchi Group. So they had a program, they had a film they had created, and somehow it ended up on Zuku Swahili on YouTube. Kada Media had no idea. They're not the ones who granted the rights. So they brought the matter to the tribunal. This is a production that had been done, I think, 4 or 5 years before the matter was brought to the tribunal, and before it was now exploited without their consent. And they tried to reach out to the company, and it was unsuccessful, so they brought it to us. And this is a good example because of how they were able to demonstrate to the tribunal their ownership. So they were able to show the certificate. Diana was a script writer, so they had the certificate to the script. They were able to show the contracts and everything, how Kada Media had commissioned Diana, and they were collaborating. They were able to demonstrate what we call a chain of titles. The chain of titles are all these contracts, location agreements, actor agreements. If you used music, the agreements, the synchronization rights and whatnot. So they were able to do that whole beautiful demonstration. And in addition, they showed their investment. I paid the actors, I paid the location, I paid da-da-da. They did all that beautifully. So when they came to, of course now it's an issue of we need to get paid. So because they were able to demonstrate that, we gave them specific damages speaking to now that investment. They spent 2 million on the production. They demonstrated it was 2 million and something. We have seen the receipts, M-Pesa payments and all that. They were able to do that. And then on top, because now this Wananchi group went and used their work without their consent, we slapped them in the wrist and we awarded another 5 million. And we said, shame on you for using this work without the author's consent. Lipa them another 5 mics. So about 7 million was awarded to the claimants. And I use this because it's really important as creatives. Keep your records, no matter for as long as you can. Remember I talked about the ownership of copyright and how long it takes. Because this work will be exploited for a long time, for a while. So you need to have those records because you never know. You might get another dispute 10 years down the line. Why would you delete that? Because that is your asset. So you have to have, just the same way you will have your shamba, you have your title deed either in your safe or at the bank. It's the same thing you need to do with your IP in film. Invest in cloud storage and keep your stuff online. And please, Aki, let's stop doing things on WhatsApp. Because again, we have situations where even as a lawyer, someone comes and says, it was mine, but imagine I lost all my WhatsApp messages, so how are we going to help you? How will as a tribunal, we won't care that you lost your messages. It's all about evidence. Yeah.
Thank you so much for that, because I think it also underscores the fact that anytime we talk about this as the creative business, there's two things there. There's the creativity, and then there's the business. And I think under the business is when we're talking about record keeping, making sure you have those receipts of everything that you're doing, because that really is going to be the story you will tell when you get to the tribunal. That's how you're going to speak to that. But Paula, very quickly also to you, because there's a lot of contracting we're talking about, a lot of paperwork that really comes to play when you think about IP. You also take it further and say it's not even about the paperwork, it's that human relation, that human connection that usually makes this fall apart. Speak very quickly to that as well.
Okay. Yeah, I say that like 80% of copyright dispute is because the issue isn't addressed. When you're in love with your script and you're talking to your director or your lead actor, I mean, the magic that is made is genuine. And it's kind of like a marriage, you know? You're just passionate about what you're doing, and maybe you don't want to break the spell, right? I mean, you know, the bride and groom are on the altar. I mean, how many times when the priest says, you know, does anyone know a reason why these people shouldn't be, you know, united in marriage? Yeah, how many times do you hear the bride say, right, so in 10 years, when we already have 3 kids and we now hate each other, who gets the, you know, Shosho's spoon? Who gets, you know, the presents that are in the room next door? Humans want to avoid conflict. There's passion and there's, you know, conflict working against you. But as Liz said, it's an asset. You know, you're not going to park your car one day and then forget where it is or not have your title, right? Protect your assets the same way that you protect your other assets, right? Yeah, so to me, it's human. You know, it's called show business for a reason. You know, act like grown-ups and make grown-up conversations happen, the hard conversations. Who's going to own this? Who's going to get the revenue? I contributed this. I should get, 70%. No, you didn't. But solve it now, because if you don't solve it in the beginning, you are in for a world of pain if things go wrong. And I know you're in love with your collaborators now, so it's very unlikely you're going to be in conflict later. But if you are, and you don't protect yourself, the consequences are very high, like maybe your work never gets to reach the public.
Thank you for that, because it's really important to have that even from the onset as you get to put this together, because there's a lot of passion that comes in the creativity business. So it's also good to temper that with the business realities of what you'll be doing as well. Paul, I also want to come to you because by the time they come to Kekobo, there's a lot that's going on in this value chain of storytelling and the production of it as well. And at the end of the day, it's only an asset, as we've referred to it here, if it's making money for you. And one of the ways you do that is through marketing and sales of what you have. And that's something they also need to think about from the onset as they get in. What are some of those issues they need to be thinking about when this goes out, when we are marketing this particular short film, this docu, this podcast? What should they think about from an IP lens now as we get ready for that?
Yeah, thank you. Of course, you are going to agree with me that the reason you are creating this particular film or this particular work is we are humans. You want to create or to make money. And one of the most important things, and I cannot reiterate more what have been talked about, contracts and cutting across even with the human relationships. Because like I said, most of the things we handle at the Kenya Corporate Board, which is enforcement, is mediation. Do you realize most of the people get into relationships, these commercial relationships, particularly in producing films, just because they are friends. They were high school friends, they are the same college, with the same universities, you are my brother, so we can just make this thing. Yeah, so you don't even have contracts, and like I said, you probably don't even have records. One of the most important things I've seen is you having a contract. Doesn't matter who it is that you are dealing with, even if it is your own mother or your own father, especially if it is your wife or husband. Ensure you have a very, very strong contract. And contracts do not mean that you don't trust the other party. Contracts are there to avoid problems or to create clarity in what you intend to do. So as you plan to create your work and commercialize that work, ensure that you have strong contracts, and those contracts should provide, among other things, what rights does each of you have, or the people who are engaged in that production have. And they should have what we call a dispute resolution clause, and we always encourage mediation. And mediation, the reason I keep stressing on mediation is because we have seen 90% of the mediation cases we handle, actually we end up having an agreement within the first or second mediation session. The reason being, people will come to a mediation session just because we started as brothers or relatives, but then this person is making money, he's no longer talking to me. So you realize that the issue is not even about the money. It is the fact that this person is not talking to you. So what we do is that we try to bring you together, have a conversation, and agree. And we don't only come at the time of a conflict, we also come in when you are contracting. Of course, when you come to Kekobo and you say, we are planning to enter into a contract, Kekobo will assist you in negotiating a contract. And like I said, for us, we don't charge. And of course, you can always go to a lawyer. Lawyers are not that expensive. And I will always advise you, if you are entering into a contract, please go to a lawyer. If you cannot afford a lawyer, because you have realized most of the creatives, probably especially startups, don't have the resources, you can come to the Kenya Corporate Board, then we can help you thrash out the contract. Again, because of course, once you have a very strong contract, it has been signed, and then you have gone to contracting. Every person you engage in that process, ensure you have written contracts and you have documentation. After that, once the work is released, ensure that you monitor your work. Make sure you know who is using your work. Make sure you know who you have licensed and what rights have you granted to that particular person? If they exceed those rights, then that could potentially be a breach of contract or an infringement. So for me, the most important things are having a strong contract. Two, avoid conflicts by ensuring that the contract provides for mediation. And again, I always tell people, please avoid litigation. Litigation, you involve a lawyer. The longer the matter takes in court, the better for the lawyer, the worse for you. So it is in your interest that the matter ends as soon as possible. And mediation is one of the ways that you can have your matter come to an end within a very short time. So enforcement is actually starts with the right holder by monitoring and taking action.
Okay, thank you so much for that. I still want to keep it in that particular vein of looking at marketing and sales, and you're out there with your product and you're going to festivals and you're meeting all of these people who want to acquire. Liz, what should I be thinking about? I've gone to Zanzibar, it's a great festival, there's a producer who wants my work, we are all excited, and then it comes down to the paperwork, and I should be thinking about this as well. As a storyteller, what should be on my mind at that particular stage as I think about contracting and getting this out to different markets as well?
Okay. Contracts, again, we have to emphasize on that. No distributor will touch your work if you don't have the chain of titles. The chain of titles confirms that you own it and you are able to control it and you have the right to distribute the work, you have the right and the authority to commercialize. So your contract game has to be on point. You had a script writer. What agreement do you have? They need to see that contract. You had all these actors. They want to see that you hired the actors, that you paid them, and understand also what scope, because some contracts may have provisions for residuals. So then they know what their obligation might look like. They want to know you cleared the location rights, because the distribution platform may be sued by the location because there was no agreement. So they're like, yeah, why are we on your production and why are we on your platform kind of thing? You're going to use music. Has it been cleared? You need the contract. You used, say, Nonini's song or Nyashinsky, get the contract. And again, with songs, it gets very tricky because in music, we have copyright and related rights. So there has to be a differentiation. If you're going to get someone to sing the song, that is a different agreement. If you use the actual sound recording, that's a different type of exploitation, and you may have to pay more money in terms of, because there will be the composition and there will be the sound recording. So it has to be, you have to be very clear as a filmmaker, if you're going to use music, how you're using it, and then a lawyer, an IP lawyer helps you negotiate that contract. I'm trying to be precise there.
Not a friend you know who
Not a friend.
is a lawyer.
Konza, let me tell you, the character development that is happening for our creatives, because I want to save a buck, I want to go to my classmate or my pal we used to play kati with to do my contract. Please, guys, just get someone. Lawyers are not stones, we can negotiate, to be honest, so you get the right advice. So all those contracts. Another thing that filmmakers don't think about, when you do your set design, there's also IP. There's IP in furniture. You need to have those contracts. Guys are not having those contracts. It's a beautiful piece of art somewhere in the lounge scene and whatnot. Did you clear those rights? Do you know who painted that work? So people are always quick to assume, oh, it was in the public. Yeah, I can use it. No. So you need an IP lawyer to help you do that, because the distributor also, they will watch the film and they're able to see all the gaps and be like, okay, I saw on minute 6.5, this happened. Where's the contract for this? You better have it. So which means you'll have a lawyer assist you with your chain of titles in the beginning. The lawyer, like for me with the films that I have assisted in distribution deals, I also watch it and I make sure that we have all our contracts. Because sometimes the creatives will get excited with some things and then you do something exciting and then you'll be like, I think it's covered, you move on. I have to watch it to make sure. Because the distributor will be like, did you guys have a lawyer? Do you have all this? So you have to be confident to say that, so that if you're going to showcase your film, even ZIF, say for example, Zanzibar International Film Festival will say, wow, let's, or all these other fancy festivals. That's what they want. They want that confidence, because no festival also wants to be sued. No platform. Netflix doesn't want to be sued. Showmax doesn't want to be sued. Canal Plus doesn't want to be sued, you know. So those are the things that they will look at, and it's a lot to do with those contracts. And you have to trust your lawyer. So your lawyer has to watch your production and make sure. And like for documentaries, it's a whole other kettle of fish. Because with documentaries, now we talk about data protection, right? You're going to do a story on GBV. Those contracts have to be well done. And again, contracts become important because in the era of ChatGPT and AI, we are trying to save money. So we're always quick to go to ChatGPT and draft a contract. My friends, it can bite you. I saw a contract once brought to me, and it was generated by some platform. And the dispute resolution clause said, the laws of the state of Georgia shall prevail. I was like, my friend, how can I help you? Like, I was so confused, and I said, yeah, you didn't have a lawyer, right? They're like, yes. So we had to figure out how to undo that whole situation. And eventually, thankfully, mediation came into play. At least this person was lucky that the other party was an honest person. But still, you know, sometimes it can go south. You can get into an agreement with the party, and they'll be like, hiya, that's your problem. You did the wrong thing, jipange, you know. So contracts are really important. And something also I want to say that's important, and I saw this in a film festival. We're always quick to also share our work without formalities. We need to stop. I know you're excited, you're meeting Sijui which director, Sijui you're meeting which superstar in the film sector, and you're always, I saw people exchanging flash drives. Oh, here's my film. Thank you, please watch it and tell me how it works. And I'm like, my friend, you don't know if this guy is going to distribute your work somewhere else and make money. You don't have presence in Germany, for example. So why are you just giving your work so casually? Ata shamba ukiuza, you want to know who is this guy, can he pay, does he have lawyers? So why would you go to a film festival and I just hand out a flash disk? So we need to start being more formal also in our work. Yes, we shook hands. Yes, Jeff is from Hollywood. But I'm like, let's talk on email, and then I can, once we iron out the nitty-gritties, I can share a link to my film for you to watch it. Don't just hand it over. So that's one mistake we're really doing in film festivals that I had to, say something.
Thank you, because like you said, at the end of the day, we also want to get our work out as far as possible, and this is a chance for you to get that potential distribution. So probably at times you forget that it's not the flash disk that should be given. Let's do it on email, and then from there I shall give the link. So thank you for that. In 5 minutes, we'll come to the question. More hands are there. More hands are there as well. I hope you have the roving mic ready for this. Very quickly, Paul, I want to come to you on this because, yes, we have been warned. Do not ChatGPT your contract. Do not get your lawyer friend who you know is in law school to go through your contract as well. But even as a creative, as you're going through a contract, what are some of those terms you should probably just be aware of before you even go to your lawyer as well, or even when you're reading it to your lawyer, some of those things you should have in the back of your mind when you're looking at a contract, some of those key terms, and then we come to your questions very quickly.
I think I mentioned this in an earlier session yesterday or the day before. When I was at Columbia Pictures and I was a junior lawyer, I got the lauded assignment of redrafting a section that goes in all of Columbia's contracts, every single one of their production contracts. It doesn't matter, costume designer, director, executive producer, casting director, everyone has it in there. The rights, what am I giving you, right? And it was 2 pages long, the description of rights. I'm not kidding. Okay, it was like double-spaced, but so it was 1 page, but it was very long, so you always have to look at the rights. You always have to look at the term. How long is this contract last? How long is this license, going to be in effect where I can't license it to someone else, right? Anything that's in quotations or bold, you need to pay attention to because they're defining a term, like giving a shortcut word to something that may be very important, like, your compensation, right? So, you get a fee for your services as a director, and then I will give you 10% of my net profits. And attached to the back of your contract is a whole attachment that describes what net projects are. And we as lawyers used to joke about it. What is net? Oh, it's 3 pages in the back of the, no. It doesn't matter what's written there. Net is nothing. Why? Because out of all revenues that the studio gets, it takes out every fee, every meal, every shoe shine. They charge interest and overhead. And so it's a joke that if you're being awarded, if you're contracting for, 5% in net profits, it sounds so exciting. From a studio picture, it's on 1,000 screens, right? Nothing. So that's a perfect example of something that's either in quotations or bold, a mini, way of expressing something very complicated and very important.
Okay, thank you so much for that. And I think that applies to very many contracts because as she spoke, I don't have an IP contract in place, but some of the things I'm like, so that's why it was in bold. And that's why they put quotation marks around it. I mean, thank you so much for some of those things you should be looking at, even as you take this to an IP professional, an IP legal professional, an IP lawyer to look at your contract. I can see very many questions in the audience. We shall start with the gentleman at the back. It's a comment. You're an IP expert. Do we have a microphone for this, Calvin? So quick comment, then we'll take it to the gentleman at the back in the white jacket.
Thank you. Thank you very much. My name is Sudi Wandabusi. I am the chairman of Kenya Film Commission. And therefore, I should start by saying welcome to Kalasha because it's ours. But I'm also an IP expert. Liz is my good friend. I am largely in trademarks. I love the conversation that is going on. But perhaps I would also like to slightly redirect us to look at advising our filmmakers on how they can exploit the IPs that they develop. Apart from protecting it, perfectly done, protecting, registering, and all that, how can they exploit them? We know of how out there, Jurassic Park, the likes of Star Wars and all that, the force be with you, a very powerful statement in Star Wars that is being used in advertising and making money. So what I would also like our panelists to talk about is how can we help our filmmakers? There's a case on Inspector Mwala and Kamwala Safaricom. They are debating on whether they infringed on that trademark, on that IP. It's an important conversation. So if you are a creator of a film, cash money, more fire and all that, how well can you push this name, More Fire, for example, and work with companies for purposes of promoting their products and you make money out of it? You have lyrics you have created yourself for a film. You protect it as a copyright. How do you exploit it? Because just protecting it and walking around with it, and the only thing you are showing is a film, is not going to help you. So there is IP protection, and then there is IP commercialization that we need to talk about and see how the filmmakers can work with owners of products, to be brand ambassadors for different products, so that you make extra revenue on the film from the IP you have developed. Thank you, and may God bless you instantly.
Thank you so much. I do hope the blessings will be instant as well. Thank you so much, Chair. Liz will address that particular issue in terms of how we can commercialize that. We'll be coming to, do we have the microphone? We'll need some assistance with a roving microphone here, if there's anyone who can help us with that, as we get to our audience on that particular one. But as we get that, we'll be starting at the back and then coming here. Liz probably can just start on that particular issue. We had spoken about how to think about it when you're actually going to, festivals and all of this. How else can you think about commercializing this IP asset that we have.
And I think Sudi brought out a very important question and conversation we need to have, because we've really idolized that the end is being on these big platforms like Netflix and Showmax, and we forget the other devices that we have at hand. So for example, once you've secured and you know this work is yours, we have the TikToks and Instagram where you need to start creating content and getting the eyeballs. Because no brand will partner with you if you're not able to show that you're also going to be going to be a return on investment in them, right? So which means that you have to have a digital strategy where you are gathering your fans. These phrases that maybe you're even creating are gaining popularity for them now to be able to have that trademark type of status, then they can be used on an ad, right? So we need to start using our social media more. We've seen our actors doing that fabulously, and that's how they end up getting deals. Look at Sarah Hassan, for example. Whatever production she's on, her digital strategy is always on point. You know what production set she's at, you know who she's working with, she's giving you a teaser, she does it fabulously. But we're not seeing production houses doing that more. They only have a strategy after they're on a platform. So we need to start doing that, being more proactive, using our social media. Likes of YouTube also have opportunities where your content can be, you can earn money from that, make it a paid up content. So exploring such strategy, and see with like YouTube, you'll be paid directly. If your work is, say on Netflix, there's a middleman. So your money won't come to you directly. It will go through your agent first, and then it gets to you. So now we have to really start figuring out how we have that, we do it ourselves. Look at Njugush and the strategies he has done with his shows. He's putting them on his website, and he's able to make money in real time. So I think we need to start being more proactive in such strategies. And maybe eventually we'll also promote our own local platforms. But as a content creator, as a film producer, start with what you have. You might be very surprised. Do some teasers, do some excerpts. Explore also different products, right? Don't just do a film. You can do shorts. Right now, shorts are a very big commercialization opportunity. And people are paying as little as 300 bob to watch a shorts. Maybe people will like it, then you do a series. If you have like 1,000 Kenyans paying 300 bob per week, how much money have you made, right? So I think we really also need to start diversifying in terms of our distribution models and how we get to the mwananchi, how we get eyeballs. Nollywood is what it is because they had similar strategies. For them, they were like, we're telling our stories, we're going to make it affordable. For 100 bob or whatever, that's how now they became the industry giant that they are. So even for us, we need to diversify our models, and we need to understand the landscape in terms of the audiences and the potential customers and all the customers we have, so that then we have different models to make money. If we're going to focus on only one, utambulia patupu. Allow me to say it in Swahili.
Okay, thank you so much for that. Any microphone there? No? I'll come there. I'll do better because clearly this might take a bit of agility. Let me come down. You're looking very fine in that dapper suit. They need to hear every word that you say, my good sir. I shall get there. Thank you so much.
Thank you, Jeff. As they say, men are colorblind. I've never had a white jacket, I swear. You said I was wearing a white jacket. It's cream. My name is Giorgio Rido, and I'm an economist, a journalist, and a creative. I have a question for each of them, and it will be very quick. For Paula, we have had Netflix specifically funding productions that use community copyright material and commercializing it without necessarily paying the communities that those materials are sourced from. For example, folk tales and folk songs, particularly in Kenya. I don't want to go the details that are out there. How do we, as a community, approach this kind of copyright infringement by Netflix. Liz, from where you sit, you know, a lot of Kenyans cannot be able to afford to seek even your mediation. So we have all these copyright infringements around, and you know, it's so blatant. If there's anything that is killing our creativity in Kenya, is piracy, and you're very aware of it. I don't know, I'm not sure whether the Copyright Tribunal is under Kekobo or you're independent. Okay, I'm making them short. I'm very short, by the way. How do you proactively make sure that Kenyans can afford the services you provide? Kekobo, many times we've pushed that you have only one CMO. Why do you insist on having multiple CMOs? Is it for the benefit of you having your finger in the cookie jar? What does it benefit artists when you have multiple CMOs?
Thank you very much for that. So what we'll do in the interest of time, because we have 10 minutes, even we shall be coming here. We started on this side. I have noticed. So we'll come to this side. Very quickly answer those questions as briefly as possible, and then we can move along.
I'm going to let Liz take the CMO.
Thank you for that guidance. We shall move along.
I'm going to let Liz take the CMO issue. We were just talking about it over here. In terms of infringement of community IP, I would just put a check on it and ensure that, in fact, what you're talking about is copyrightable and that it's not in the public domain. And, but if there is like an appropriation of something that is copyrightable and copyrighted material, you get a lawyer to send a lawyer's letter, you know, straight to Netflix general counsel. I mean, send an email. You just say, you are exploiting my rights without the right. Take it down now, or we're going to take legal action, even if you're not going to, because the threat is important. I was telling Liz just earlier, there was when I was at Warner, there was a very big movie coming out with like an $80 million budget and probably $20 million in marketing behind it, so like say a $100 billion investment. And guess what? They did not listen to Liz. They did not have proper chain of title. And a week before the movie was to premiere all over the world, day and date, Warner Legal got a letter saying, excuse me, you forgot to get some rights from me. And guess what? They went to court and got a preliminary injunction. It means stop. Studio, stop. You are not allowed to release this film because there is a good chance that this guy has not been properly compensated. So again, high consequences.
So I'll answer the question on the tribunal. So number one, the tribunal is under the judiciary. One of the things about our tribunal is good to know is that you can represent yourself. Tribunals are flexible. They're not like ordinary courts. We are more flexible and much friendlier. So we are able to guide a self-representing party. So for you, your key issue is, as a creative, as an IP owner, have your evidence. You remember the evidence I talked about in the example, right? You have your evidence, because as long as you have that, then it's a sure bet that you're likely to win, as long as you can prove the work is yours. And then at the Secretariat, they're able to help you put together your claim and how you now file your case. Now, the beauty with the tribunal also is that you will have a judgment between 30 to 90 days. See, you want to get paid. We are the guys who make sure you get paid if your work was used without your permission. You come with your evidence, and we get you sorted. By the 90th day, you will have your money if your copyright was truly infringed and you are able to prove it. So, you know, litigation, an ordinary court, you'll be stuck for 2 years, 3 years. IP has a shelf life of a banana. If you want to get paid, come to the tribunal. 30 to 90 days. You have a judgment, you've created precedents, and everyone now knows not to mess with you. You've created industry standards, because again, each case would come with certain nuances, right? Then we're able to make pronouncements on such. And then just to weigh in on what Paula answered, I think something we also need to understand, when this community property is being infringed, sometimes we go after the wrong party, especially in litigation, and that's why it will take long. Because you're going after Netflix because you're thinking deep pocket. Netflix has a legal team that will play a serious legal strategy that you won't understand. You're forgetting that there is a production company. There's that company that came and shot the production, either in Kenya or from wherever, and they used some community rights. That's the person you go after first. Because Netflix will hide behind the agreement they had with the production. And they have very serious agreements in terms of the liability and whatnot. So then you'll find there will be that merry-go-round and whatnot. If you go after the production house doesn't want their content to be taken down. They will dig deep in their pockets and figure it out. But again, also, in terms of community ownership, we really need to get our act together as Kenyans. Borrow examples from the likes of India and China. For us, if right now I was asked, what does the Kikuyu community own? I'm not sure. Aside from what I know by association of marriage, I have no idea, right? So we need to figure out our documentation game. That is where tumeanguka mtihani. So we need to figure that out so that then we are able to transform them into proper assets that can be clearly cleared legally and the communities gain. Yeah.
Very quickly on the question of CMOs. On the issue of why probably there is a push for a single CMO, this is an ongoing conversation. It is not a position that has currently been taken. We have received a lot of comments and views on that position. Some people have argued that it is creating a monopoly, which is not healthy for business. But then, as the regulator, we are not only looking at the side of the right holder or the CMO, we are also looking at the side of the user. Assume we have like 10 CMOs. Me as a user of a copyright work, does it mean I'll pay 10 licenses? So the confusion multiple CMOs are likely to cause on the side of the user is why we decided to open up this conversation so that we can determine whether we maintain single CMO or multiple CMOs in order to encourage competition in that field. That is why we opened that conversation, and we are overhauling the Copyright Act, and I will actually urge you guys to put in your comments on that bill, because one of the things we are proposing is to have a CMO for each of the sectors. If, for example, we have film, we have a CMO for film. In music, we have a CMO for music. If it is literary or books, we have a CMO for books. That is what we are proposing. That creates a balance, because if you are a user of audiovisual works as well as music, then you'll need to pay 2 licenses, as opposed to having 5 CMOs for audiovisual work. That means me as a user, the potential of creating confusion is that you'll have like 10 people coming to me for a license. So it is a debate that is going on. We are looking forward to get your comments, and allow me to also, in brief, mention the issue of the community work. And he mentioned folklore. Folklore initially was protected under copyright, but when the Traditional Knowledge and Traditional Cultural Expression Act came up, it was moved. Now it is protected, not as copyright. Folklore, folk songs, and those traditional cultural expressions, the old stories that were being told, are now being protected under the Traditional Knowledge and Traditional Cultural Expression, where if you are using a traditional cultural expression of a community, then you must negotiate with that community and ensure there is a benefit that is flowing to that community. It could be a school that you build there, it could be capacity building, all those things. But you must have, there is a way they call that benefit, there is an agreement you must have with that community.
Check. Thank you so much for this opportunity. I think my first question is probably to all of you. Do we have a space for this kind of community? You know, we need this kind of community so that this conversation does not end here. Like I'm so much fascinated about the tribunal. This is the first time I'm hearing about it. But do we have a community or spaces where we can continuously get this kind of conversation? Because whatever you have shared here, some of us have come late, you know, but it's already so much to grasp. I would really want to think about something like that, that we think about probably having this community so that then we are able not just to wait for Kalasha or some events or engagement, so that we are able to be in a space where, in one way or another, I can contact you and just say, hey, I'm looking forward to this and this. How do we go about it? And how can we advise around this? So that's really, really critical that I wanted to get perspective on. I think another key thing, maybe for Kekobo, is we've seen global institutions or organizations coming here, and they are coming in with policies that, in a way, do not favor local artists. Example, I say Spotify. Spotify, one of our colleague industry friends, Dana Seda, has been raising issues on how they are trying to exploit local artists, okay? That you load your song on Spotify, I pay premium, and then the artist who is in Kenya is not getting standard benefit for that. So how is Kekobo also looking at these global organizations to protect local artists? Because the conversation here is about protecting us against exploitation. And I think that is really, really critical now that we are going to the bigger future of digital assets and digital spaces, you know? And I think last but not least is for Paula, how do you, I know there's a thin line between working for organization and creating probably content for organization, especially corporates that most of us want to work for because they pay money that pay bills, you know? But the truth is, there's also some element of exploitation that comes with engagements with them, you know? They pay you an extra amount and then you realize 5 years later or 10 years later, your content is still being used and you don't know how to go about that. So first, community, Kekobo, how do you protect local creators to ensure that the digital platforms we are highly accessing are not exploiting us? And lastly, for Liz, how do we contact you beyond this? How do we engage you beyond this panel discussion so that it's okay to ask you really questions that will help us shape the future of our content? Thank you.
Thank you so much. What I want us to do is hold on to those questions because there's a group here that is pressed for time. So please mark community, global enforcement, and what we'll do right there, it was these two. So questions as well.
Good afternoon, everyone. So my name is Amata, and I'm an advocate of the High Court of Kenya, specializing in entertainment law. Someone somewhere is wondering, what's the difference between an intellectual property lawyer and an entertainment lawyer? A very big difference. An intellectual property lawyer is a jack of all trades, but majorly a master of none, right? Then an entertainment lawyer is a master of one trade, majorly copyright law, right? So I'll start by saying, I first of all dispute that if you have any issue, like regarding contracts, you go to an IP lawyer. Times have changed. Kenya is grown. There are entertainment lawyers in the country now. And it is better to go to an entertainment lawyer as compared to an intellectual property lawyer. Why? An intellectual property lawyer majorly teaches you how to protect your work. But an entertainment lawyer is going to be with you from when the idea is in your brain till when it becomes a product, and afterwards they will also help you protect it. And that is why the CEO of the Kenya Film Commission also raised that problem. Why is it that there's no conversation about exploitation? There's no conversation or major conversation around exploitation because majorly the people who are handling the conversation are intellectual property lawyers, and it would be best if Paula would speak more of that because she's an entertainment lawyer, right? Secondly, I'd also want to say that it is very worrying that the Kenya Film Commission put this, this session to happen for 15 minutes. That is so wrong. This conversation, intellectual property for the film industry, needed 1 hour because this conversation is about money. Is about money, right? So, lastly, let me summarize it for you guys, right? Because I said I'm an entertainment lawyer. All right. You as a film professional, you have whatever you want to work on, right? The first procedure is look for an entertainment lawyer. What will the entertainment lawyer do? Start with something called production legal. Production legal, they will do all the legal work? No. They will do all the legal work for you, and that's the legal work revolving production. So there's contracts for above the line and below the line crew. Figure out. Secondly, you'll move to development legal. Development legal, they will handle clearances. These are title clearances, script clearances, then they'll handle consents. They will handle rights, and that is where the chain of title comes in. Then lastly, they will help with the financing of the product. Homework, go home and figure out how negative pickup contracts work. They exist, and we are bringing it to Kenya. Then they'll move to distribution legal. They'll handle the legal work when these OTT platforms like Netflix, YouTube, etc. want to use, or like you want to distribute your product. Lastly, they will handle the advertising of your project. And advertising is self-explanatory. Surely, a project that has moved from production legal, development legal, distribution legal, and advertising legal, surely is going to become financially successful. Lastly now, my take home for everyone, right? In the film industry, a Kenyan film producer is going to come to me and tell me to draft for them 4 contracts for the whole thing, for the whole movie or the whole series. Why? Your counterpart in India would come to me or would come to my company, and we don't do less than 22 contracts. And you expect to make more than $100,000. Be serious. This thing is about money. If you want to make money, use money and also pay people well, so that there's cash flow in the film industry and the film industry grows.
Jeff,
Thank you very much.
Can I take this one?
No, just hold on. I wanted to use 5 minutes just to work the room. And just for clarity, it was more than an hour of conversation, probably called the last 15. But thank you so much for your passionate expression. Very quickly, as we go around, please have one question. Keep it really short. If it's a comment as well, really short. You only have 5 minutes. And then we get to our panel to answer those questions or respond to your comments as well.
Thank you. My name is Kevin Mwiga. I'm a journalist and a filmmaker. I'd like to ask about the NRR, the website where people apply their copyright. If somebody applies their copyright and it's not his project, how will you know this person is infringing somebody else's work? And the next is, you have talked about the rights of how somebody can get the rights of their actors and discussions of all that. Let's say, for example, I did something and it was more of friendship, and then now the thing is booming as we don't know because people have watched it. So how can we go about it? And then lastly is about the contract generation if seeking a legal advice. So how can a emerging filmmaker go on that? Thank you.
Thank you very much. I saw some hands on this side of the room. I hope you're noting all of those, because when you come back there, it's a real rally. It's over here. Okay, so very quickly, these three right here, question or comment very fast. I don't want to cut anyone off. Here you go, Jen.
Thank you very much. I want to thank the panel for the useful insights. My name is John Kabagambe. I'm a lawyer from Uganda. I'm also into film production. One of my questions goes to Mr. Paul Kaindo. You talked about economic rights and moral rights. Would you kindly, for everybody here, try to shed more lights between the divide between economic rights and moral rights? Secondly, about the Copyright Tribunal. East African creatives are forming what I'll call creative coalitions. Someone in Rwanda teams up with someone in Uganda and another person from Kenya to work on a project. Now, I understand the Copyright Tribunal would carry out enforcement on Kenyan soil. But what if there's a script, there's a DOP from another country, there are all these kinds of people in the region coming together, and then one of them registers, all rights reserved, is the copyright owner. And another one in Rwanda or Uganda infringes. He's not the owner, but there's been infringement. And I understand your enforcement is municipal, it's for Kenya. How do you help someone on Kenyan soil whose rights have been infringed by another person in the region?
Thank you so much. In the interest of time, because I am being told you need to bring this to a close, I'll let you respond to those, and if you have a bit more time, we'll go to the last two gentlemen at the back. Please let us proceed. We can start with you, Paul, because yours has really been around the domain of how you enforce outside of our borders. If you could please speak to that, then we'll come to Liz and Paula.
Thank you. Those are very interesting questions, and I like the conversation and the interest coming from the audience. Let me start with the question, I sort of didn't capture the name, on policies that don't favor local artists, where global organizations come to Kenya and exploit artists. My take on that is, one, I think what the Kenyan government has done is to open up the market for artists. They have ensured that right holders are able to commercialize their work on global platforms. And again, the laws of Kenya provide for what you can do and what you cannot do. It grants the rights for Kenyans. So your rights as a right holder are provided for under the relevant laws like the copyright law. How you commercialize them now becomes contractual. Now, when, for example, you engage Netflix, that is a private contract between you and now that particular platform, or whatever platform that you are dealing with. We may not be able to control what you agree, because there are a lot of terms and conditions. It is up to you either to agree to them or not. But the reason why you'll find those international platforms or foreign platforms probably paying less here as opposed to other places is because of, I don't know how to put it, but it is about the market viability. If you have content, if you are a content creator, if your content is being commercialized here, how much money is it making from the Kenyan market? And how much money is it making in another market. So if it is making more money in a foreign market, automatically you'll be paid more revenue from that. If content from the US is making more money here in Kenya, of course that person will collect more. So it is about the algorithm, how much your content is generating in that platform is what is going to actually determine that. But the laws are there. It is private contractual arrangement. Again, we are overhauling some laws. There is even the culture bill that may be able to address that. The copyright bill is online. And there are proposals to even charge, I don't know what to call a tax, but there is an amount of money, could be a very, very minimal amount that is charged on users that goes to the creatives. Those are the proposals that we are receiving as we amend the Copyright Act. To the other one was Wakili, I think it was Wakili. Sorry.
There's a lot that has been brought up in terms of what happens outside the border. How does Kekobo protect creatives with their work outside of the border?
Okay, we do have, of course you'll be given the chance to respond to that, but we have what we call the Berne Convention. And if your work is protected in Kenya, Kenya is a signatory and a member state of the Berne Convention. The Berne Convention is the mother of copyright. And it provides that if our work is protected in a Berne member state, and most of the Berne member states are the UN member states, then your work is automatically protected in another member state. For example, you create a work in Kenya, that work is also protected in Uganda or Nigeria, other Berne Convention member states. That is how the international regime works. However, I do have the what we call territoriality, meaning that if your work is being infringed in another territory, you enforce those rights in that territory as a creator. But it is under the Berne Convention, your work is protected. Amata Wakili, Amata, I think we note your concern, but my view would be, you see, intellectual property cuts across. And creative works, like a film, is not only about copyright. There are other IP aspects that fall in. Entertainment lawyers are very, very important. They guide, but also an entertainment lawyer should not just be a copyright lawyer. For me, I refer myself to a copyright lawyer because, of course, there are the copyright aspects in music, copyright aspects in software, which may be in the health industry. But I believe intellectual property lawyers are equally important because they cut across beyond copyright. The question on NRR. We said that Kekobo has what we call a voluntary registration system. Voluntary registration system in the sense that registration is not mandatory, but it is encouraged. So some of the jurisdictions have a voluntary registration system. In Kenya, we have what we call nrr.copyright.go.ke. You can register your work very easily on that particular platform. Currently, there are no charges, but we will be putting up the charges very, very soon. So the question was, how do you ensure that works, that if somebody else has registered their work, you'll be able to know? The way the platform is created, the way it is intended to be, let me say intended to be created, is to be able to identify works that are already registered. So if somebody tries to register a work that is similar with another, that should be, will actually be, will be noted. So the person who is verifying the registration will get a notification that say this work is already registered, or this work is 50% similar with another one. That functionality, as we speak, has not been activated, let me be honest. So you'll find that we have had disputes where somebody has registered a work, but then somebody else comes and say, no, this work is mine. And you know that what we say is that if you register a work that belongs to another person, knowing very well it is not yours, that in itself is an infringement, which can attract either criminal or civil remedies. So the system, as we move on, is going to be designed in a way you cannot register a work that is similar with another one that is already there. To John, you asked me to clarify on economic rights and moral rights. Economic rights, we already listed the exclusive rights that a right holder has. The right to distribute, the right to sell, the right to translate, all those rights. Now, these rights are what I like calling money rights. These are rights you can sell, rights you can commercialize, rights you can license, rights you can make money out of. Those are economic rights. Like, for example, if you have a film, you can license a platform or somebody else to distribute that right for a payment. So you'll be receiving either royalties or whatever amount you have agreed on. So those exclusive rights that were mentioned are what we call economic rights, because you can either license for money, you can assign for money, or you can transfer in any way for money. Moral rights, on the other hand, are what we call, they are personal rights. For example, the right to paternity, the right to be identified as the owner of that work. That you cannot sell. But it is a right, if you have created a film, you have the moral right to be identified as the author of that film. Another moral right is the right to object to distortions that may be prejudicial to your character or your character. So if, for example, or your work to be used in a way that, that affects your character. If, for example, you are a Christian, you don't want your film to be shown in a club or in a brothel, you have the right to stop it because your character is at risk. So moral rights are those personal rights which may not necessarily make money, but you are supposed to control those rights. I think those. Thank you so much.
Thank you so much for addressing those issues. Paul, I'll come down to Liz as well.
All right. I'll try not to repeat myself in some of the questions. So there was a question around creating a community. I'd say this, if you're able to curate a community, I'm happy to come and assist and do trainings. I've been doing this for the last 14 years. I also lecture at Strathmore University and I teach entertainment law. So that's my forte. I'm happy to collaborate. We can do online webinars and whatnot. So after this, I hope we can speak and we work something out, because I recognize there's a new generation of filmmakers and we are happy to spread the education and help you seize all the opportunities that are available currently. Then there was the question on an emerging filmmaker. Oh, let me start first. There was a question on your IP is used by your friend. What do you do? So for me, by the time we're going to litigation, that's the last resort. A good lawyer will also assess how did you come together, what were your plans, what went wrong. For me, I would want to sever first that relationship, right? So that if worst case scenario, this other party is being unreasonable, then we move to plan B. But I've always advised my clients where friendships have gone awry, we try and mediate and try and make things work, because some of the best projects have been also created through friendship, just that they didn't know how to navigate that friendship and they didn't have the hard conversations. I've seen those so many times. We've had situations where we even had to call a security guard because tempers flared, but we understand it's part of humanity. So it also means that also you as a creative, talk to your peers and even your mentors and ask them, hey, when you had a dispute, who did you use as a lawyer? And then now they introduce you, so that then you have the right person assisting you with that, and you achieve your right goal. So by the time we escalate, we've tried everything else. That's what we would do, and help even with the strategy. How do you talk with your friend so that it doesn't get really bad? And then as an emerging filmmaker, how do you get access to legal? Right now we are having a lot of creatives registering associations and guilds, and it's beautiful to see that they're also putting the legal infrastructure. Seeing some of my fellow colleagues also now being head of legal in those departments, in those associations, and they are working towards creating a pro bono division where you're a member and you have access to legal, so you can pursue that. The other option is you come together as friends and say, we want to put this project together, let's find a lawyer, and resource pool. Like I said, lawyers are not stones. You can come and say, we have 5K, we first need to understand what we don't know, and then we figure out how to work together, right? So if you come and say, me, I have 5K, and Wakili, I just need to understand my rights, no one will walk away from you. At least me, I know I won't walk away from you, but negotiate. So embrace that negotiation. That notion that lawyers are expensive is unfounded. Protective lawyering is always cheaper than defensive lawyering. So when you come when you don't have a burning matter, it's easy to negotiate. When you come when there's wahala, then that's another conversation. Because your wahala becomes my wahala, I can't sleep. At 2 a.m., I'm there thinking, oh my gosh, there's this situation, kind of thing. And then the question on the tribunal and the creative coalitions. Paul's talked about the Bern Convention and those shared principles. But in addition, I would say where there's these cross-production engagements, the best way you can even give our tribunal jurisdiction is by submitting to our tribunal in the dispute resolution clause, because it will help you resolve that dispute faster. And then, of course, make sure that in your strategy, you're also registering your copyright in all the countries, or at least understanding the nuances of copyright. If there's voluntary registration, also ensure that you register in the contract, address those issues, who is in charge. Because again, with cross-productions, people are not allocating roles accordingly or in a manner that they understand and that makes sense. So you need to have that. So if you ever get into a cross production, I would say engage an IP entertainment lawyer to help you formalize that so that it's easy, because we're able to see where issues may arise and how they will be resolved fastest. Kenya is the only country in Africa right now that has a solid copyright tribunal for copyright industries. So we are at a point of advantage and should be easy to take advantage of. That means that then even now for cross-production engagement, if you submit to the tribunal, you have a dispute resolved within 90 days. You can't get that anywhere around the continent. South Africa has an ad hoc. An ad hoc simply means the copyright tribunal is constituted when there is a case. So you can imagine by the time it's constituted and your matter is listened, it will take a while, right? Our tribunal is consistent, it is there, it exists, and you can find us. copyright@court.go.ke, that's our email address. I'll repeat, copyright@court.go.ke. So if you ever find yourself in a dispute, that is where you send an email, and then we are able to guide you on how to file your matter and assist you if you're going to be a self-representing complainant.
Okay. Thank you so much for that. Liz, finally, Paula, on your end, as we bring this to a close.
What they said. There's very little for me to add at this time, but just know that the three of us sat back there and said there is absolutely no way we can even make a dent on this topic in a way that can be useful in this amount of time. And I think all the questions are valid and great. And Liz and I we're talking to the KFC and other bodies, and as Liz said, happy to come to your place and do trainings and stuff. One of the questions up here, I'm sorry I didn't catch your name. Okay, second row guy staring at his phone with the blue shirt on. Anyway, was you were asking about, oh no, they're still playing my song, and I licensed it to them in 1932 and it's 2026. How do they keep using this? Well, again, documentation. If you don't have it documented, you're in trouble. And it's a question often of bargaining power. And I'm not going to be shy here because there's nothing that I want more than to see Kenyan content being consumed in a more aggressive way throughout Kenya. I really think there needs to be more content here, if I may say that as a guest in this country for over 15 years. And we need to figure out, you, whatever, I know I'm just a white girl here, but an American, don't blame me for that, a system that works commercially, that is affordable by the available audience and is distributed in a way that still monetizes for the creators. I think all this talk about studios and Netflix, I mean, those are, Netflix pulled out, Amazon pulled out of here. We got to do it here, And the question of bargaining power, when you were saying, the company I licensed this to is still using it, bargaining power. did you give them a perpetual license? You probably don't know. Did you give them the license for the tracks that were recorded? Did you give them, it's all in those details. I'm sorry to say, but that's how it works. And it's why it's complicated. It's, I wasn't brave enough to be you. I wasn't brave enough to be creative and create stories that touch other people's hearts and funny bones. I wasn't willing to be that vulnerable, so I did the chicken thing of going to law school and learning all about the business and business school. So I'm passionate about film. I love film. All of my advice and all of my work has always been to promote creators. And thank you for doing what you do.
Okay, thank you so much for that. Because of time, we'll have to bring this conversation to a close, but I can assure you this gentleman and ladies are ready to connect even after this for the nitty-gritties, because there were two we didn't get to there. You can please connect with them on that, and of course, if there are any other issues, creating community and the likes, they're here for that. I'd like to thank this amazing panel and audience engagement as well. Paul Kaindo, Liz Lenjo, Paul Alowit, thank you so much for your time, your gems, your insights. A round of applause for them, tafadhali. Thank you so much. Oh, they demand applause for me. Thank you. Thank you. This brings us to our lunch break. We're a bit into lunch as well. I've been told there's a lunch activation right outside. And then in the next 20 minutes or so, we'll be back for another session. So we take lunch, and we're back in 20 minutes. Thank you so much for your time. Bon appetit. Good afternoon.